My name is Rebecca Musgrove. I'm one of the barristers at Park Lane Plowden Chambers. He specialises in court protection. I am the head of the court protection team there at the moment. Today's talk is hopefully a kind of not going to be too long, so 20 to 30 minutes. The idea of it being along with lunch, so either enjoy your lunch while listening, or it'll be short enough that you can have your lunch afterwards. Please feel free to pop any questions in the chat box or put your hand up or just shout out any questions as we're going through this. I know some of you probably will already have dealt with this and worked with me on a couple of cases where this issue's come up recently. So the talk today is about the straightforward bit, which is how to appoint a litigation friend. Hopefully everyone knows that bit. That bit's the straightforward bit. The tricky bit is what to do when you start to run into problems and that you're concerned that you're not getting proper instructions from the litigation friend. So we're not talking about the official solicitor side of things, because often they will be giving you proper instructions, but more the sort of situation where you've got a family member or a friend who's been appointed as a litigation friend. So, where do we start with all of this? So the starting point is the Court Protection Rules, Part 17, Practice Direction 17A. All of you will be familiar with this, I've no doubt. So a person may act as a litigation friend on behalf of someone mentioned in paragraph 2 if that person can fairly and competently conduct proceedings on behalf of that person and has no interest adverse to those of that person. So what we're going to look at is what the case law says about how we in effect define those things. So what does it mean to be able to act fairly and competently, and what do the kind of things do we need to look at in terms of is there no interest adverse to those of that person? As we know, the persons whom a litigation friend may act are P, a child or a protected party. Obviously, for the purpose of this, we're going to be focusing on P and court protection proceedings. The court can either of its own initiative or on the application of any person direct that a person may not act as a litigation friend, bring to an end a litigation friend's appointment, or appoint a new litigation friend in place of an existing one. And we'll come on to the case and what we do in terms of that. So we start in 2011 with a case by Mr. Justice Mostyn called AB and TC, a local authority. And what he says, so he refers to Mr. McKendrick as one of the advocates in the case, that a litigation friend should be required to confirm that they'll act in P's best interests, fairly obvious. That derives from the context of the statutory scheme as a whole. We've obviously talked about what the rules say, and a litigation friend who's unable to give such confirmation would not be appropriately appointed. So it sounds like it's fairly straightforward, but as we know, when we get into the facts of cases, it sometimes becomes a little bit difficult as to what does that mean about whether you can do that. So we then come on to 2013 in a case called Re-UF. And Mr. Justice Charles talks about, from that starting point, it's submitted essentially on, in this case, AF's behalf, and that they've got no interest adverse to those of her mother. So you will all probably have encountered cases where, for example, you have someone who's maybe been a deputy for health and welfare, possibly even property and affairs. They've then there may be a son or a daughter or a grandchild, or they've then been appointed to act as the litigation friend, and you're hoping therefore that they're able to do that. But inevitably, what a lot of these cases look at is that when we have family members acting as litigation friend, it can start to become a bit tricky. And we'll look at the situations in which that can become tricky. So he says, looked at in isolation, I can see that there may be some force in the argument, but there's no conflict between, in this case, what Mr. Justice Charles is saying, between the daughter and mum, who is P. The genuinely believes that what she's asserting is in her mother's best interest. Again, I think that's not an uncommon position that we often see. But it seems to me that you must read the rules, be read and applied in the context of the overriding objective and the circumstances of each case. So in effect, what he's saying is, well, you can have, as we know, you can have family members acting as litigation friend, but you have to look at it and it's very fact specific. So he refers to the overriding objective. again, everyone will be familiar with this, but the obvious things, I think, so being able to ensure that P's interests and position are properly considered is probably particularly relevant in terms of the overriding objective for our purposes. Deal with the case in ways which are proportionate to the nature, importance, and complexity. So I think sometimes, particularly for family members, the issues which they think are important might not be the issues which us as lawyers think are important. And so when they're acting as litigation friend, they're going to have to be able to understand those differences. Um, and understanding maybe that the court won't want to litigate every single point. So overriding objective always applies, as we know. RUF then also goes on to talk about, I agree that members of a family, even if there is a family dispute concerning P's best interest, could, albeit I think rarely, appropriately act as P's litigation friend in proceedings. And I think that's where maybe there's a little bit of a disconnect, because I think there is a lot of cases where actually family members do act as litigation friend. I wouldn't necessarily agree it's rare. I think there are actually quite a few cases where they do that, and we know that because often the official solicitor will only accept that invitation to act if it's absolutely an option of last resort. So they'll want to know that family members have been considered and why family members are not appropriate. So what RUF in 2013 goes on to say is that the litigation friend, the proposed litigation friend, would need to demonstrate that he or she can, as P's litigation friend, take a balanced and even-handed approach to the relevant issues. The obvious situation which is going to come up there, of course, is for family members. This is very personal. It's probably very emotional, and sometimes it's quite difficult for them to take that balanced and even-handed approach to the relevant issues. Which is in effect what it goes on to say. It's a difficult task, it's emotionally involved, and sometimes if someone has a particularly strong view, then we need to try and balance that out. And obviously, if, for example, the family member is the one who's perhaps gone to you as a solicitor and they have, in effect, it's been brought as a Section 21A challenge because the family member is the one who has alerted you to the situation, that can then sometimes be a bit tricky because you've got to manage those dynamics as to actually your ultimate concern is that your client is P, and you need to try and balance that. Yes, the family member might have their heart might be in the right place, but they might not be able to be as objective as you're going to need them to be as litigation friend. So it's still on RUF. There's a bit more there, just in bold, about in what he talks about is in this particular case, it just wasn't possible for the family member to be able to act fairly and in a way that wasn't adverse. He says essentially that's because the proposed litigation friend, the daughter, has an argument which she definitely wishes to run in advancing the best interests of her mum, coupled with a family history, means she can't realistically consider the alternatives. So, in essence, stating the obvious, but you need P to be able to weigh up in the balance the different arguments. So, is the person who's going to be litigation friend this particular family member or friend, are they able to actually see the pros and cons of each argument? Are they able to actually be able to weigh that up, or are they so set in their ways and so determined as to what they think should happen that actually you just can't really discuss it with them, in which case they're probably not going to be a suitable litigation friend. We then get to 2015 and we have a case of NRA, again, Mr. Justice Charles this time. He talks here about, indeed, by applying the best interest test, the litigation friend may have to control all aspects of the proceedings and may have to take a position that is contrary to or does not fully accord with the express wishes and feelings of P. Again, I think perhaps it states the obvious, but for a family member, that obviously we understand that becomes much more difficult, because if you are going to potentially have to be dealing with cases where you're maybe talking about medical treatment or you're talking about really difficult issues, then it's probably going to be the case that it's going to be very difficult for them to separate the emotion out of the decisions. And also, they may have a strong, for example, it's not uncommon for a family member to say, well, my parent always said that they never wanted to go into a care home, for example. But it might be the case that actually it's just not possible or realistic to have a care package at home because their needs are so extensive, or their health has deteriorated such that you're starting to work towards end of life care. Now, that I think is very difficult sometimes, therefore, for a family member to say, but I don't want to go against my mum or dad's wishes. And in that case, I think actually it's, as lawyers, we know that we can only deal with realistic options. And so sometimes, again, it might be the case that they start to become unsuitable to be litigation from, because if they don't understand the fact that we have to work with realistic possibilities, and they can't get past the fact that a decision might have to be made contrary to their family members' wishes or feelings. That again might suggest that you're getting into territory where maybe you need the official solicitor instead. So I think that's just a repeat of that one. And then again, there's a couple more passages there just from this same case. Just so I'll send these out afterwards, just so you've kind of got them if you ever need to use them for a position statement or skeleton argument. They're all there. And then you get to where I think one of the things I think which is helpfully set out in this case is that exact kind of dilemma that I've talked about. So Mr. Justice Charles talks about the performance of that role will often mean that the family members, for example, have fought Peace Corner over a long time to promote their best interests, and will be they might be the obvious appropriate litigation friend because they know them best. And so it's not a definite family members can never be litigation friends. It's just that we need to exercise some caution when considering that because of the difficulties which may arise. Very helpfully in this case, at paragraph 164, he sets out a series of things which are in the PowerPoint slides that we need to look at. So he talks P's participation in the decisions relating to the care package and proceedings and a fully informed consideration by the court of a determinative test by eliciting P's wishes and feelings, critically examining from the perspective of P's best interests with a detailed knowledge of the pros and cons, what's least restrictive, what's the available options, keeping the implementation of the care package under review, raising points relating to it. And I think in terms of those, I think some family members will be very well equipped to be able to do those things, but for some family members, they might just find it quite overwhelming, the volume of instructions or information that's actually needed from them. And then 2 paragraphs on, he kind of summarizes this in 2 ways about how this problem might arise. So the first is, does the fact that an issue relating to deprivation of liberty arise mean that the independence required precludes the appointment of a family member or friend? And second, if it doesn't, when would it be appropriate to appoint a family member or friend? And in some ways, it's perhaps easier to say when it wouldn't be appropriate. When their interests collide or things like that. So, for example, you might have a situation where P's family members, for example, are also deputies for property and affairs. And in particular, you might have those where if they're making decisions around the finances, but they're also people who have an interest in the finances. So, for example, they maybe already own a share of the property because it's been set up in a way to try and keep the assets in the family. So it can be a bit tricky if P's family members who and say a son or daughter is going to act as litigation friend, but you're going to maybe have to make decisions in the case about whether, for example, the family home should be sold in order to free up capital or assets to pay for a care home. But it turns out son or daughter has a 50% share in that property, then obviously that can then become a conflict of interest as to actually who are you able to separate out your interest in the property versus what you need to do for your mum and dad. And I think for a lot of family members that will be quite a difficult decision for them to be able to make. So NRA again goes on where he talks about it's likely that in many cases the relevant local authority or others who the family member or friend has dealt with in connection with the care P will be able to see and demonstrate whether for those or other reasons the relevant person should not be appointed as a litigation friend, or whether they would be suitable because they have acted and are likely to act in the way set out in paragraph 164 above. So I think a lot of the time, obviously, social workers or medical professionals may have had a lot of contact with these family members, and I think we'll probably have a good idea as to how reasonable they are and whether or not they're able to act in P's best interests. And I think that's where my experience of these types of situations is that the court will expect all parties to have a view. So the court will be very interested to know actually what the other professionals on the ground who've been dealing with this day in, day out before you maybe got into the COP, actually what is their experience of this individual? Do they think this individual is appropriate or not? And actually, that's something that obviously you need to try and raise as soon as possible, as soon as it becomes an issue. Still on NRA again, the NRA is one of those cases that has a lot of these little checklists in it, so it's kind of a bit of a go-to when you have these applications. You've got all these other interesting cases before and after, but this one has the kind of helpful little checklists in it. So paragraph 170, it says, the role of a litigation friend in RPR involves them forming a view on what's in P's best interest and advancing it, although it may not accord with what P is asserting. So again, comes back to that some family members will find it very difficult to go against the wishes and feelings of their loved ones. It says anyone performing that role may well have to advance a solution that doesn't accord with their objections. So that kind of situation we talked about where it may be that their parent doesn't want to go into a care home or and has always said that, but ultimately that's what their needs are dictating at this point. An independent litigation friend. Oh, sorry. I've just lost my slides. 1 second. An independent litigation friend may well have to advance argument that does not accord with P's express wishes. Indeed, this is not uncommon. And thirdly, the point that P is expressing objections that a family member or friend concludes or is concluded do not accord with their best interest, do not in self preclude them. So it's difficult, isn't it, to weigh up? But I think, again, it comes back to that being fact specific and also comes down, I think, to the individual personalities involved in these cases. So paragraph 100, it's fact and case sensitive. It's going to turn on the circumstances of the family member involved. And I think it's that judgment call that we all have as professionals as to, do we think this person can really act independently in P's best interest? I think as a blanket rule, it's going to be fairly obvious that if there are cases that's going to have a significant degree of complexity, I think sometimes the way to sell this is actually it's far better for the official solicitor to represent their family member or family member, and then they can have their own voice and they don't have to filter their voice, they don't have to filter their views, and they can say whatever they want to say, whatever they disagree with, in whatever terms they want to say it. And that leaves kind of P then free to obviously be represented through the official solicitor as a litigation friend, and perhaps makes your lives a bit easier as well. I think probably if you've also got cases, I think the other scenario I can think of is probably if you have disputes between family members. So if you maybe there's been a family fallout and you've got one half of the family thinks mum should go to placement A and the other half thinks mum should go to placement B. Again, I think that's probably the sorts of situations where if you can anticipate from the beginning that this is going to be quite a fraught family dispute about whatever the issue is, then having a family member as a litigation friend again is probably not going to be a suitable scenario for the obvious reasons that I think it's best that P obviously isn't caught up in that. And the official solicitor can more independently take a view on that. And then we've got some more recent cases. So 2019 with McDonald. And again, summarise it. First, the litigation friend must be able to fairly and competently conduct proceedings. Second, have no interest adverse to that of, in this case, it was a child, but in our case, it would apply to P. And he talks about obviously the ordinary course of a litigation friend and what that involves, and being able to do all of those things and be able to look at kind of what's in P's best interest, being able to safeguard P. And then the second bit is paragraph 23, which is the central role of legal advice in the discharge of the duties of the litigation friend has been emphasised by the court. The need for the guardian and I'd like him to act under proper legal advice. So obviously I said this case was in the context of a child who was represented through a litigation friend. Equally applies to P that there will be situations where obviously it's not the case that they simply can't be litigation friend because they don't accept your legal advice. But if you're getting to a point where they just don't, for example, if the legal advice, for example, was to do with, but these just aren't realistic options and we can't advance a case for a placement which is just fanciful, then that is something obviously which would get into the realms of actually you can't act as litigation friend because that's not just a case of disagreeing with you, that's about fundamentally not understanding the legal framework in which we're working. So again, it's a little bit more nuanced, but I think it'll be fairly obvious if there is a situation where they're just not able to kind of weigh up the legal advice that you're giving them. It might be that you're saying, look, you can do this course of action, but here's the litigation risks with it. And again, it might be that they just don't understand that or can't really see the argument around that. And it sort of sets this out in paragraph 24. So the second is that whilst the litigation is required to act on legal advice, he or she must be able to exercise some independent judgment on the legal advice they receive. So equally, you don't want someone who just says yes, 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 yes. That's not what we're here for. You want the litigation friend to appropriately weigh that up with objectivity. And then he says, within this context, there's long-standing authority that a litigation friend who does not act on proper advice may, so it's not a must test, it's a definite may, be removed in that circumstances. And that sometimes is where ultimately you kind of butt heads with family members in particular. Again, some of this is just set out so that you can use it in future contexts. And again, he kind of, in this case, you've got kind of a repetition of that earlier case of just saying, they might have a deep affection for P. It doesn't mean they can't act, but they've got to be balanced and even-handed to the issues. So a bit of a summary. If you think there's a conflict of interest that may arise between P and a family member or friend acting as a litigation friend, try to address the issue at the outset of proceedings. That's not just an issue for those representing P, it's an issue for everyone. So if the social workers have concerns, if the medical professionals have concerns, it's really important that everyone addresses that at the earliest point. If you think that there might be a conflict of interest because you're going to have to make decisions at some point about, say, as I said, for example, around about finances, and it turns out that the friend or the family member who's going to be the litigation friend has their own financial interest in those assets, then again, that may be something to think about. If there's going to be a dispute between family members, again, that's a likely conflict of interest that may arise. So again, those kind of obvious situations, I think best to address them as soon as possible. Best to kind of have that conversation very early on and say, actually, it might be better for the official solicitor to act as a litigation friend and for those family members to be a party in their own right. It's always going to be fact and case specific. There's not kind of a blanket one rule fits all. And I think have a solution ready. So if you are in this situation, then make sure that if you're the person representing P, you've got a kind of solution. So you've contacted the OS and you've got that information available for the court. And I think probably the other obvious point is obviously if P is not going to have a litigation friend for a period of time, then in terms of what directions can be made, really you should only be taking neutral steps. Again, how you interpret those neutral steps can be quite broad, but if it's simply that you're going to gather information and request further information, I think it's better you kind of get on and do that, because otherwise you're just going to order those once the official solicitor is on board. But anything that's sort of substantive really should be awaiting until the official solicitor has come on board once the judge has made that decision. I think my experience is that if you're raising this, most judges will be very sympathetic and will be inclined to agree and discharge the family member as litigation friend and appoint the OS instead. So I hope that's been useful. Does anyone have any questions? So question, at what point would a conflict of interest arise for the solicitor, i.e. if originally instructed on behalf of a family litigation friend who was then discharged, an invitation act is sent to the OS, at what point, if any, would that solicitor be conflicted out from acting for P? I think that's a good question. I think I mean, I guess it depends what you've been told by the family member. I mean, I guess if it's within the proceedings and that information is very public, then arguably you should be able to continue to act for P. I think it's very much going to depend on what they've told you or not told you. So if, for example, I'm trying to think, if the family member, for example, had told you that some assets existed that was not known about, but which would materially alter maybe the financial assessment or things in proceedings. Obviously, you couldn't withhold that information. So that might create a bit of a difficulty. I could see that sort of situation. I think if it, in terms of kind of straightforward welfare, I think it really depends on kind of what they've told you, but I think most of the time I would expect that you'd be able to continue to act. Certainly for P. Obviously, I assume the family member won't want you to continue acting for them because you probably told them that you think the official solicitor should be on board. So I suspect, knowing most family members, they won't have taken that news well. So yeah. Does that help, Hannah?
Oh, yeah, it does help. Thank you.
That's all right. Did anyone else have any questions? Nope. Okay, well, thank you all very much for joining. There is going to be some more Law with Lunch sessions, which no doubt you'll get emails about as to what topics they're on and who's running them and the dates of them. But we're hoping to run some more of these quick kind of lunchtime sessions. So if you get asked for any feedback, please provide any feedback. Very much appreciated so we can kind of tailor it to what's useful and what's not. Thanks, everyone.